Aditya, my friend and colleague Aditya will put out the information about how you can get in touch with us and how you can interact with us and join our ASCL community. And that reminds me, Asian School of Cyber Laws also has a community dedicated to speaking about concepts relating to arbitration. This is free for anybody to join. It's not a paid community. It's just a group of ADR enthusiasts who've come together in which all of us interact, share information and thoughts and concepts about ADR, including mediation and arbitration. And you can feel free to join that community. Aditya will be sharing the details of that community on the chat group very soon. So without much further ado, Dr. Aditya Nain, Dr. Bharat Nain, they're both on the call, but Dr. Bharat Nain is the one who's going to be having a majority of the conversation with us, and Aditya and I'll try and chime in. Dr. Bharat Nain is a qualified arbitrator, and his portfolio and his set of acquired skills is long enough to occupy a very large portion of this discussion. So I'm not going to go into that. I'm going to specifically restrict my introduction to the fact that he is a qualified arbitrator, and he's written the book that we in our course material very heavily rely on, called FAQs on Arbitration. It's a wonderful book in case any of you are interested in reading about it. It's available on Amazon. Dr. Bharat Nain, thank you so much for joining us. And I'm going to be your host. My name is Gokul Narayan, and I'm also an ADR enthusiast, and I'll try and lead this conversation.
Thank you for having me over. Thank you.
Thank you. Thank you for your time, Bharat. So let me begin this conversation with you, Bharat, by stating the very obvious fact. An arbitration clause or an arbitration agreement forms the very basis of a contractual dispute between parties. But having said that, a very elementary question that a lot of people who interact with us have is, what is an arbitration clause? If you could just begin by clarifying that one simple concept.
Simple. An arbitration clause is a joint agreement between the parties, which is captured in the contract in the form of a clause. It's a joint decision that any disputes in the contract linked to the contract directly or indirectly will be resolved through arbitration. It's a factual commitment of an agreement between the parties as a clause in the contract.
So an agreement between the parties to resolve disputes if and when they arrive within the scope of a contract can be called an arbitration clause.
That's right. So
it leads me to the next question, the very simple question that, is there a difference between an arbitration clause and an arbitration contract, or do they mean more or less the same thing?
See, an arbitration clause is a clause within the main body of the contract. Okay. It's a separate agreement.
Okay.
An arbitration agreement can be a totally separate agreement from the main contract as long as it draws reference to the main contract. An arbitration agreement simplistically can be an exchange of mails between parties confirming the arbitration clause or confirming that they will resolve the dispute through arbitration. Practically speaking, both are the same. Whether you say arbitration clause or arbitration agreement, it means the same.
All right. So just to understand this further, for example, if you and I are in a contract, let's presume that it's a service contract. You're the service provider and I'm the consumer of the service. We don't have a dispute resolution clause in our agreement for some reason. The lawyers who have advised us are not very good lawyers, and apparently they don't know about arbitration clauses or dispute resolution clauses, so they've not incorporated it. Later on, we come up with a question to our lawyer saying that there is no dispute resolution clause, can we address it? They create another agreement in which arbitration is mentioned. So are you suggesting that this would be the arbitration agreement referring to the initial contract?
Yeah, it's a separate agreement in which arbitration is agreed upon jointly, preferably signed by both with a reference to the original agreement. Okay. That's it. Okay. It can be created after the original agreement has been signed also.
Correct. So just to make it clear, an arbitration agreement or an arbitration clause, since now we're going to try and use it synonymously, need not be a part or an essential part of a contract.
That's right. Need not be a part, essential part of the contract. If it is separate, as long as it draws a reference to the main contracts, it's enough.
Okay. All right. So, Dr. Bharat, will you now throw a little bit of light on how these arbitration contracts need to be created in such a manner that they protect the rights of the parties before the dispute arises? And possibly, I know this is a very broad question, so maybe you can break it down as per your understanding for our audience to understand. So what is a good arbitration agreement and what does it entail?
Okay. An arbitration clause basically captures the decision between the parties. Arbitration is effectively a dispute resolution modality for the parties, with procedures decided by the parties, with arbitrators that can be selected by the parties, with fees paid to the arbitrators by the party. Effectively, an arbitration clause is a child of an agreement between the two parties. It need not be decided by the lawyers. It need not be decided by the third party. The two parties to the contract or the parties to the contract will decide. As this visual in front of you will tell you.
I've just shared the visual.
Yeah, as the visual will tell you, there are 12 basic points which should be there in an arbitration clause to make it robust. I'll go through these points very briefly, one by one, and then we can have questions and answers later. Sure. The first point is, which disputes will be resolved with arbitration? Is it all the disputes linked to the contract or only part of the contract? Let me give you an example. Suppose there is a contract to construct a 33-story building with civil, electrical, and mechanical infrastructure. The contract can be in two parts. One is a civil infrastructure. Second part can be electrical and mechanical. You could say all disputes linked to erection of the building, including civil, mechanical, or electrical, or only refer to the civil disputes. So which disputes? You have to be very clear and say all disputes linked to this contract. Otherwise, if anything is omitted or if this is unclear, the validity of the arbitration clause is going to be a question mark. Under which statute or act? In a domestic arbitration, it will be resolved with the Arbitration and the Conciliation Act 1996. That should be mentioned in the arbitration clause. That the arbitration disputes will be resolved through arbitration as per the Arbitration Conciliation Act 1996. If you don't mention which act, that leaves it totally vague and it can be invalid. Now, the third point is a point where the biggest confusion happens. Most parties are not aware, or unfortunately, most councils are not aware that the rules of arbitration, the procedural rules, can be decided between the parties. There are also institutional rules. There are global unilateral rules. You can say the UN rules will apply, or the parties between themselves can decide the procedural rules. From my practice and experience, I can tell you 80% of arbitration clauses don't mention this. Parties that don't have a role to play, it's left to the councils. In the end, it is left to the arbitrators to decide. That may not be in the interest of the parties. That could delay the whole arbitration. So remember, you are the king, you can decide, you're the king and the queen, and you can decide the procedural rules. Point number 4, do you need a sole arbitrator or do you need 3 arbitrators? That depends on the value of the contract. So please specify that in the arbitration clause. The powers to be given to the arbitrator. Now, the powers to be given to the arbitrator can be part of what is in the procedural rules, or the parties together, under advice through their lawyers, can decide what powers are to be given to the arbitrator. If you adopt institutional arbitration, they have a very standard set of robust rules. You don't need to worry about that in that case. The 6th and the very important one is ad hoc or institutional arbitration. Let me explain. Ad hoc arbitration is when arbitrators will decide, let's have a meeting this week at the Opera in Bombay. We will meet between 10 to 5. In the end, the meeting will be there between 11 to 4. There'll be 2-hour lunch break. Everything will be decided by the arbitrators or the council through the arbitrators. The parties have no role to play. it ends up becoming an expensive affair where you have to host the meeting, you have to make the preparations of the meeting, and you have no control on the time. If you do institutional arbitration, the institution takes over the entire back office procedural modalities. There are institutional rules, the timings have been set. As per the institutional rules, the procedure of arbitration is decided. The powers to be given to the arbitrator are decided. Very often, they have a standard fee structure which the arbitrators have to adhere to. So, in your clause, mention that the arbitration will be conducted by XYZ arbitral institution as per the prevalent institutional rules. It's a small expense to pay the institution, but the benefits of this are mega, are huge.
Bharat, just a clarification on this, if you may, please.
Yeah.
I'm trying to draw a reference with clause 3 and clause 6 over here.
Correct.
Clause 3 specifically referring to the procedural rules, and clause 6 referring to how ad hoc or institutional arbitration, how you can choose between the two. I'm presuming, tying it with point 3, that even if the arbitration is ad hoc, that means conducted not under institutional rules, you can adopt the procedure which is used by an institution. So, for example, if you pick up the MCIA, which has its own rules, or the Singapore Arbitration Center, you can pick up their rules and apply it to ad hoc arbitration. Please correct me.
Correct. Ideally, even if you have ad hoc arbitration, pick up the UNICITRAL rules, UNICTRAL. They're international, they're robust, they're very simple to follow. So even if you have ad hoc arbitration, pick up institutional procedures and rules.
Fair enough. Thank you so much for that.
Sorry, there's an error. There are 2.6 over here. The second 6 is appointment of arbitrators. There has to be a procedure which you can decide on appointment of arbitrators. You can say each party will nominate one arbitrator. The two between themselves will nominate the presiding arbitrator. Or if it is a sole arbitrator, you could say the parties will jointly agree. One party will give a list of 5 names. Second party will agree or disagree. If within 3 weeks or 2 weeks or 30 days, they are unable to decide on a name, then they will approach the court for appointment of an arbitrator. Let this appointment procedure be very, very clear. That eliminates a lot of confusion. A lot of people feel that if I have given the name for appointment of the arbitrator and the other party doesn't agree, I can go ahead and proceed with the arbitration ex parte. No, a court has to come in. So best is to specify the procedure with respect to the appointment of the arbitrators. Now, point number 7 is an interesting thing. And point number 8, there's a lot of confusion between the seat of arbitration and venue of arbitration. Seat of arbitration is where the applicable law is. In India, you will say, as per the laws of India, any dispute with respect to the arbitration, the proceedings will be addressed in the Mumbai court or the Pune court or the Delhi court or the Indore court. Now, this point of seat is more important in the case of international arbitration. Suppose one party is Indian, one party is German, the arbitration venue is Singapore, which law will be applicable? The parties have to decide. You could have either the German law, the Indian law, or the Singapore law. And city question comes in a country like India, where there are multiple locations, parties in different cities, which courts will be responsible. Point number 8 is just venue, physical venue. Seat and arbitration are two different things where seat does not mean the physical seat, venue means the physical venue. You could even specify the meetings will be held in Bombay in the meetings rooms of the XYZ Chamber of Commerce. It could be decided. Language of arbitration. It is the decision of the two parties which language to hold in the arbitration proceeding. It could be English, it could be Hindi, it could be a language selected by both the parties. Suppose you select arbitration meeting will be held in Bengali. Then you have to ensure that the arbitrators are conversant with Bengali in terms of spoken Bengali, written Bengali, reading Bengali. So you have to be very clear on that point. Now, this point is more important in the case of international arbitration. We go back to the original case, that German company and Indian company. You could say the arbitration proceedings will be held in English, but the arbitration records will be available in German and English. So that could be decided. Next point is about costs. The physical costs of arbitration, the meeting room, the institutional arbitration. So who decides the costs? Simplistic manner is you can say that the costs will be divided equally between the parties. But if that is not specified, that becomes a point of dispute during the arbitration proceedings or when the award is made. There is a lot of controversy of late on next point number 11, fees payable to the arbitrator. If we are selecting retired High Court and Supreme Court judges, till recently, they had a fee schedule which was really exotic, which was beyond the control of most parties, but the parties had no alternative but to follow that. But what most people should know is that the parties can decide what are the fees payable to the arbitrator. If the arbitrator doesn't agree, look for another arbitrator. Or if you're doing institutional arbitration, the institution has a charter of fees, in which case the arbitrator has to agree on that. Or the best modality is that the government has come up with a Schedule 4 in the Arbitration Act with a suggested fee structure. Follow that blindly. That is safe. There is going to be no controversy, because if there is a controversy on fees payable to the arbitrator, that can derail the whole proceedings. Last point, very few people know about, but which is going to come into prominence now, is there are different types of arbitration clauses. You can have a negotiation arbitration clause in which you can say the parties will spend the first 30 days in negotiating between themselves. In case they are unable to reach an agreement, they will then go to arbitration. If they skip the negotiation, the arbitration proceedings cannot start. They will be invalid. Second is mediation arbitration, in which a mediator is appointed, a period is decided by the parties. If within 30 days, the mediator is unable to assist the parties to come to a decision, the parties will go to formal arbitration. This is going to be more important because there's a new mediation act which is going to come within the next 6 to 8 weeks. The last one is conciliation arbitration. A conciliator is a person who assists the parties to resolve to find a solution. If the solution is not found, the parties can go to arbitration, but very importantly, the conciliator cannot be appointed as an arbitrator. If the parties have found a solution, the conciliator writes an award, which is called a conciliation award, which is binding on both the parties, which is like an arbitration award. Ideally, if you cover these 12 points in an arbitration clause or an arbitration contract or an arbitration agreement, you are perfect. For those of you who are part of this course, go to page Aditya, do you know where we've got a sample arbitration clause?
Yeah. Gopal has the book in front of you, right?
Pardon.
Yeah, I'm just trying to get the sample.
Towards the end of the book.
Yeah, towards the end of the book, we have a sample. We have arbitration clauses from different institutions, and the authors, Aditya Nain and myself, we've drafted a sample arbitration clause.
You can continue, Bharat. As soon as I get
Yeah.
the exact page number, I'll just let you know.
Yeah. So there is a sample arbitration clause, which is a robust clause on page 267 of the book. For those of you who are members of the course, you have a copy of the book. Goes to page 267. For those of you who wish to purchase it, there are multiple types of arbitration clauses given on page 267. Go through those 3 or 4 pages, you'll get a bird's eye view.
Right.
I'm
Bharat,
ready to take any questions.
Yeah, Bharat, before we get into the questions, of which we have quite a few, there's some which have been sent to me. Let me just exhaust those questions before Aditya takes over to answer put forth the questions which have been put up in the chat group. Now, one clarification I was hoping you could give our audience is, I'm presuming just like in conciliation, in mediation or in negotiation also, since the nature of dispute resolution mechanism is different, the negotiator or the facilitated negotiation under mediation or the conciliation cannot be carried on by the arbitrator. Just to reiterate.
Correct.
So mediator cannot be the arbitrator. There has to be a separate mediator, and we would presume it would be wise to select the mediator also prior itself, just like the arbitrator is being selected.
If the parties can decide to appoint a mediator in advance, it is great. Or you go to a mediation institute who will nominate a mediator for you.
Correct, correct. So just like in arbitration, the systems which have been created under institutionalized mediation would be more preferred because it's more structured as of right now. All right.
Correct.
A specific clarification, Bharat, on point number 1 in that sheet that you put up. In a contract, is it possible for parties to decide that there will be certain aspects of the contract which will be resolved through arbitration and some others which may be resolved through other dispute resolution mechanisms like litigation? Can there be a distribution of aspects in the contract?
ADR is about autonomy and agreement between the parties.
Correct.
Whatever the parties agree between themselves, whichever methodology and modality, as long as they document it, it can be done. But
Correct.
the more the complications you put in the arbitration clause of the contract, the more difficult it is going to be, the more disputes which will arise. So if you can keep the clause simple, unambiguous, you're sitting on a winning wicket.
Correct. But if the need so be, it's not a problem. You can do it, like you said, because it's party autonomy. Whatever the parties need can be addressed. So you can have one part of the agreement between the parties being addressed through litigation and another part which specifically talks about arbitration.
Yeah, litigation, arbitration can be separated, but if you put only mediation and only arbitration, if it is not resolved through mediation, and if you don't have a med-arb clause, it's a stalemate.
It's a stalemate. It will become a problem.
Yeah.
Yeah. And just one more point of clarification before Aditya takes over. Aditya, I'm sorry. In terms of the appointment of the arbitrator,
yeah.
We are suggesting that either you have a sole arbitrator or you each party appoints one arbitrator and the two arbitrators together then appoint the third arbitrator. In your point of view, if cost was not a factor to be taken into consideration or wasn't a problem between the parties, would you suggest that having more than one arbitrator would be helpful? Because you can see a lot of pendency of cases in the high courts for appointment of arbitrator. And I'm presuming it is in cases, and please correct me if I'm wrong, I'm presuming it's in cases in which there's a sole arbitrator.
Not necessarily in cases where there's sole arbitrator. The procedure of appointment of arbitrator in the high courts is stalled because of the sheer volume. That's it.
Okay.
But the number of arbitrators should ideally depend on the quantum of the dispute. If the total contract value, for example, is 20 lakhs, having 3 arbitrators is a pointless exercise because the costs and the fees are going to be tremendous. The time taking is going to be tremendous. I would say in the Indian context, generally, a figure of 8 to 10 crores, people go with a single arbitrator. More than that, there are 3 arbitrators. Internationally, the figures are much, much higher. $20 to $25 million would be a single arbitrator, which is about 200 crores. And more than that is 3 arbitrators. Okay. The more the arbitrators, the more the complications and procedural time taken and overall costs.
Absolutely. Thank you so much for the clarification. Aditya, please take over. I'm sorry.
No, that's fine. So we have questions on the chat box which we will now take. The first question is, can the parties decide the arbitrator at any point of time before the dispute arises?
Yes, ideally, if both the parties are able to agree on the name of the arbitrator at the time of signing the contract, that's perfect.
I think what we also want to emphasize here is that these things should actually be specified in the arbitration clause itself. I think that's the point that we're trying to make and emphasize as well. Either the name of the arbitrator or more likely the process by which the arbitrators will be selected can be added as part of the arbitration clause itself.
That's right.
The next question is, if the parties are from different countries and they fail to decide the seat, which seat is applicable in the case?
If the decision on the seat has not been made in the arbitration clause, then you're looking at a mega huge controversy. Then it is up to if the court has been asked to appoint an arbitrator, the court could decide the seat, or the arbitrators themselves could decide the seat. They will examine the contract. They will see which is the applicable law. Is it the physical venue which will be more appropriate, or is it the size of the contract or the nature of the contract? Then it is up to the decision of the arbitrators or the court. That becomes a very complicated issue. Recently, there has been a case where the court decided that it would be appropriate of Singapore as a venue to take it as a seat of arbitration. But that is the point which leads to the biggest disputes. The seat and the venue should be decided in advance.
We have another question just to repeat the clarification of seat and venue. So I'll just seat refers to the
Aditya, your video is lagging.
and
Aditya.
venue refers to
Aditya, your video is lagging. May I just pose the question to Bharat, please? All right, thank you. So Bharat, one of the questions that we have is if you could repeat with an example the difference between seat and venue so that it becomes clear. I think there was a little bit of lag in the video at the time when we were speaking about it.
Okay, seat of arbitration effectively means what are the laws or which courts will be responsible for any dispute that happens during the process of arbitration. Venue is a physical location. Now, suppose it is a domestic arbitration between a party in Pune and a party in Visakhapatnam. You could say any disputes with respect to the arbitration procedures will be addressed in a court in Vizag. The seat is Vizag. Now, suppose it is a party in Germany and a party in India, then you have to decide, is it the laws of India applicable, or is it the laws of Germany, or you could even have the law of China applicable. It depends on the parties to decide. The venue can be a fourth place. In today's world, the venue is also online. It is acceptable. Though it is said the venue is Mumbai, one of the councils could be, one of the arbitrators could be sitting in Mumbai. The other arbitrator is online from Singapore. But the award is signed indicating place Mumbai. So it's the party's decision.
All right. So just to clarify again, venue means the place where physically the arbitration
Physical place.
is. All right, thank you. Bharat, we have time just for about one or two more questions. Before I ask the last two questions, I just wanted to reiterate, people, please feel free to join our arbitration community. It's free of cost. We put up information about the latest cases that are being discussed in the courts. We have discussions on them. You're free to ask us questions, whether it may be from a professional point of view or just curiosity. And Bharat, Aditya and I will try and answer those questions for you. So please make sure that you join our community. The venue, sorry, not the venue, because the venue is going to be online, but the date for the next session, and we'll keep having these sessions with Bharat on different topics of interest. The date for the next discussion will also be placed, would also be put up on the arbitration community, so make sure that you join it. Aditya,
are you able to hear me, Gokul?
Yeah, now we are. Some people are asking for the arbitration.
I've put the link a couple of times. I've just also put it up again. The community Gokul is talking about is nothing but a WhatsApp group. So that's the link that I have put up. Please join that. Already people have joined. I've seen that based on today's call.
Isha Patel has asked a very interesting question. Isha Patel, can you address, Gokul, can you take that?
She'd asked a few questions earlier. I'm just going to, then we'll take off one more question after this. Isha's question is, can we take the example of, sorry, we've just moved down. Can we take the example of house documents wherein the parties decide to resolve the dispute through arbitration and wouldn't go to the court?
What do you mean by house documents? That's not clear.
Yeah, I'm a little unsure as to.
Yeah, Isha, can you respond? What do you mean by house documents?
You can feel free to unmute yourself and clarify the question, Isha, if you so choose to, or you can.
We have a number of other questions also.
Okay, by the time she puts the clarification, we can go to another question.
So one question is, what's the difference between conciliation and arbitration?
Conciliation is a procedure decided where a conciliator is appointed in place of the arbitral tribunal. The conciliator assists the parties to come to a solution, cannot decide on behalf of the parties. The conciliator can engage the parties into a discussion, can encourage them to talk independently without the conciliator being involved. If the parties arrive at the decision, the conciliator can be informed that this is what you arrived at, and the conciliator writes their word. an arbitrator takes the decision by taking into account all the documents submitted to him and the evidence examined. Conciliator cannot take the decision.
Just to provide a little bit more clarification to that, a conciliator basically is a form of dispute. Conciliation basically is a form of dispute resolution, which is a facilitated negotiation. Negotiation between the parties is taking place. It's facilitated by the conciliator. The conciliator generally in this case, so it's a collaborative form of dispute resolution as opposed to arbitration, which is an adversarial form of dispute resolution like litigation. The conciliator generally also happens to be a subject matter expert. Just to throw in a few more points. I know all of you have questions, but we've got another session that's going to start off very soon. So what we'll do is join the community. Make sure, Atish, thank you for asking the question. Please copy it. Isha, please clarify your question. Advocate Ridhima.
Isha has clarified, I'll answer her.
Right.
Isha, you said house documents basically means a sale deed. If the sale deed has an arbitration clause, it can be resolved through arbitration. If it does not have an arbitration clause and the parties do not agree to arbitration, then it goes to litigation. So the trick is right at the initial stages, when the sale deed is made, when your contract is made, when your transaction is documented, put in an arbitration clause.
Yeah.
Any more clarifications, put it on the group and in the community. I'll be happy. I will answer the questions.
Thank you so much, Dr. Bharat, for taking out the time on a Friday evening. Dr. Aditya, actually, I'm not going to call you Dr. Aditya.
Any other questions now?
There are a few more questions, Bharat. I've copied them. I'll be putting them up on the group so that we can take our time and respond to it. For a clarification to everyone, we will be providing a link to view this conversation with Dr. Bharat on the group itself. We'll share that link. It will be available for about a week. Feel free to click on that link and go through this conversation all over again if you so wish to. And for those people who are not able to join in, we will be putting up the recording on the group. I have noted down, Aditya, can you also note down the questions which have been put up so that we don't miss out on any? All right. Aditya, you wanted to say something before we sign off?
Just 1 second. This will take some time because I'm trying to download the chat. But for some reason, I'm not able to figure out how to do it.
All right. I've copied the questions, Aditya, so that's fine.
Okay. All right. Thank you. No, I just wanted to point out, Gokul, just before we leave, that for those of you, because I know a number of participants are thinking about registering for our online certificate course. So I've already, Gokul, if you can, because my internet is not great, if you can please once again put up the link to our course on Asian School of Cyber Law's website so that people can immediately get the link to it. If you have the course, we will take it separately. Feel free to get in touch with Gokul and he'll direct you to the right people for the right question.
Yeah. So I've put up the link for the course and I'm putting up our numbers as well. I'll put up my colleague's number. Her name is Chaitali. She's the one who handles, she's a faculty with us and she's the one who handles the course. I'll just put up her number. Feel free to reach out to her and she will clarify all your queries.
If any queries come on the community group, you will get a detailed answer from us.
One second. Sorry, just a second. Chaitali handles the academic questions and administrative questions that you may have for the course specifically. The course faculty are, of course, 3 of us and also a couple of other faculty members who we get.
All right. Thank you so much, Dr. Nayan, for sparing your time on a Friday evening. Aditya, thank you so much for sparing your time on a Friday evening. I think this was a very intense and good conversation. It was quick, and we hope to do this more often, and we will let you know as soon as the next conversation is planned. Everyone, thank you so much for joining in. Have a wonderful weekend and hope to see you soon. Bye-bye.
Thank you. Thanks. Bye.
Thank you, everybody.
Thanks.